Thank you so much, Mr. MC Compare, for this very warm introduction. The chairman of today's event, Justice Wale Habib Abiru, Justice of the Court of Appeal, our distinguished journal reviewer, Professor Robert Merkin, KC, the President of the Lagos Court of Arbitration, Professor Wale Olawoyin, and members of the board present, ladies and gentlemen here present, and those who are joining us remotely. I'm so very pleased to be making these remarks. Professor Olawoyin, when he took over as LCA president a couple of years ago, he set for himself a vision to revive and focus, at that time, rested Journal of Arbitration and Dispute Settlements. And he cast it in the mold of the Arbitration International. For those who are familiar with journals, the Arbitration International is a foremost journal established by the London Court of Arbitration, International Arbitration, LCA, and Professor Olawoyin understood that this was a very important tool that will help propagate and promote the image of the Lagos Court of Arbitration. And so it was in these circumstances that I was invited to join the editorial board of the LCA, along with my colleagues, Dr. Hakim Seriki, who is based in England and teaches arbitration in one of the universities, Professor Ofonze Amuchaze, Senior Advocate of Nigeria, Mr. Unduka Ikei, Mrs. Chinwe Odigbo Ogu, and by no means the least, Mrs. Seun Olonchime. At that time, I must say that setting up another arbitration journal was daunting for us. Even though, as Professor Olawoyin has mentioned, a journal had been set up, but after one issue, it fizzled out. And so we essentially were starting way from the beginning, ground zero. We didn't have tools to work with, and we had to create a structure, secure funding, identify an editorial philosophy and direction for the journal, and we also had to register the ISSN number with the National Library. And more importantly, we had to source for manuscripts, and we had to create awareness for the journal. So it was quite a lot of things. At that time, also keep in mind that there were some 35 separate journals, fantastic journals across the world. In arbitration, alternative dispute resolution, conflict management, or dispute settlement. And they were all being published by reputable international publishers. Now, I already mentioned Arbitration International, published by Oxford University Press, but Oxford University Press was just not publishing Arbitration International in the area of arbitration. Oxford University Press was also publishing Journal of International Settlements, as well as the famous ICSID Review, where investor states articles find a home. Cambridge University Press was not left out. It was also publishing arbitration and dispute resolution law. CLUA Law International also added its voice. CLUA Law International publishes the Journal of International Arbitration, as well as the International Journal of Arbitration, Mediation, and Dispute Settlement. Swiss and Maxwell, a foremost publisher, was also in the game. They were publishing the International Arbitration Law Review. Juris Arbitration publishes European International Arbitration Law Review, and so on and so forth. Now, these are just journals that have as part of their title Arbitration ADR. But there were also several mainstream business journals that actually accommodated arbitration articles. So this was actually the circumstances in which we were created, and we understood that our work was nicely cut off for us. But we were determined, because we actually saw prospects for this journal. and we went to work. And what we did was that we actually did some research. For those who are familiar with late Amozu Asosu's work, International Commercial Arbitration and African States, published by Cambridge International Law Press, he identified in that influential work 3 separate generations of arbitration laws on the African continent. But this was 20 years ago because that work was published by Cambridge University Press in 2001 rather. It's 20 years after, and we are not talking of those 3 generations any longer. African countries are now publishing, or rather they are now passing laws on arbitration.
Recording in progress.
That actually appear to be moving away from the ancestral influence. Nigeria is the most recent, but some countries preceded Nigeria in passing these laws, and some countries would even take over from where Nigeria stopped. So we really felt that we actually had material to work with, and that really was encouraging. And because of that, we set for ourselves an editorial philosophy, and I quote, a tool for research, teaching, and practice in this area of law in Africa that caters to scholars and researchers, as well as arbitration, mediation, ADR practitioners, and administrators, in-house counsel, students, and decision makers. We actually were shadowing, excuse me, the Asian International Arbitration Journal. For those who are familiar with this journal, we would know that it is actually the voice for the Asian continent when it comes to arbitration matters and allied issues. So this was actually, in a way, what we modeled ourselves after. But it's nice to fiddle with theory and have a vision. Is another thing to actually actualize these things. So we knew that we had set a fairly tall order for ourselves, and we understood that in order to accomplish these lofty dreams, 2 things were very important for us. One, we needed to attract very lively topical issues, and at the same time pay a keen eye on quality control. 2, it was very important for us to have a very attractive journal, well-packaged journal, because we were comparing ourselves or competing. We understood that we were competing with the best. And we wanted to be in that space and also attract very useful materials, not just articles that were not very, very helpful in terms of the philosophy we had identified for ourselves. And so this is what we framed our philosophy to be. This is what we set out to execute. And I'm very proud, my colleagues and I are very proud that before you today, we have our first issue. If you look at it, it's designed in such a way that we can accommodate articles that are between 6,000 and 8,000 words. With our permission, you could actually climb up to 1,000 words, but you need to let us know. We also have a segment for case comments. For instance, the Q&ID case that was recently published, like the Trident and UBA case that discusses Section 4 and 5 of the Arbitration and Conciliation Act, and that even though the Arbitration and Conciliation Act is rested now, that provision survives in the Arbitration and Mediation Act. So this segment is meant to attract reviews of cases like this. And then we have a third segment, and that has to do with practice notes, experiences of arbitration practitioners in the field. And so this is how we've designed it, and that's the fourth one is actually, the third one rather, the practice notes, has a maximum of about 4,000 words. We adopted for the journal house rules, the very, very well-known Oxford Standard for citation and of legal authorities, commonly known as scholar, is a common tool, so people should not have a problem accessing it. And of course, I'm so very proud that we are able to be cited as this particular edition, 2022 won LJADS. So for now, this journal carries 4 articles. I'm not going to touch on the articles because we have a journal reviewer that I believe has a responsibility for that. And I don't want to speak from the point of bias, but I should say that as the president mentioned, all these articles were very vigorously reviewed by 2 separate people per article. And because we understood that if we are going to be in contention at all, there has to be articles of great quality that we're publishing. And so some of our authors are here. We are happy to have you in our midst, but I should also say that we are grateful for how you endured the time when we're having a back and forth about providing feedback from our reviewers. Thank you so very much. I just want to end, Chief Ganifarimi, late Chief Ganifarimi, when he came up with the Nigerian Weekly Law Reports and he started publishing it, he was interviewed and he was asked, what's the motive behind these law reports? And he responded, he said, I want to democratize legal knowledge. I believe that with this journal, we would be able to deepen knowledge on arbitration in Africa. There's so much we can do. What we are hoping to do is, we know that the concept of arbitration and around ADR and mediation is so well developed. All the principles are developed and we can hardly say that they are still evolving. However, we believe that this journal provides a platform to share perspectives from the standpoint of Africa, one. We also believe that there is so much going on in Africa that can actually be explained to the world through this journal. These 2 things are important to us. So I mentioned earlier on that Nigeria has passed an Arbitration and Mediation Act. We are hoping to do a special journal where we are actually going to unpack material aspects of that law and explain it to the world. The world wants to know what is the underpinning philosophy and how did we go about it. This law, before it was passed, was pending for a while before President Tinubu came and signed it. We have the arbitration, Chartered Institute of Arbitration conference starting from tomorrow, and looking at that, we will see that we have very exciting topics and panel discussions. There is talk about affirmative action. I remember as a student in the University of Dundee, my professor, Thomas Wilde, who's passed on now, he sent me to a conference in Canada. There were about 6,000 of us as delegates. I was one of about 5 black Africans in attendance. I came back and I reported to him that I felt he was skewed against us, and immediately, he was German, he did something about it. Got in touch with the World Bank, and he said they needed to set up a project for affirmative action. He passed away in 2010, right in the middle of supervising me, so that project died with him. I guess it is time for us to revive it. So it's interesting to see this come up as a topic in the conference that is starting tomorrow. But beyond the talk shop, I guess we need to approach this intellectually and see what we can come up with. And there are other topics like that. There are also ethics in arbitration. I think that, Africa needs this more than the other continents. So again, these are things we are going to be looking at. I want to end by expressing appreciation to the LCA crew, especially the president, Professor Olawin. They have been so very supportive. They kept away. They didn't influence our editorial content. They didn't pressure us to publish any article or to remove any article. They allowed us to work very independently, and they were supportive with money, even though I must say that they were also very stingy with that. Just for the records. Thank you very much. I also want to I'm talking about the fact that it was important for us to bring about quality control. We knew that it was pointless going to the US or the UK to find publishers, but at least it was important for us to find the best in our environment, and in that sense, we were able to secure the University of Lagos Press, which for us was a big thing. So we're also very grateful to the University of Lagos Press for publishing it, and we hope the relationship will continue. I want to thank authors. All of them are unable to attend. 2 of them are residents in the UK, and I believe that they are joining us remotely as I speak. But I'm grateful to Mia SAN, and also to Oji Uka. And I hope that it won't end here. Yeah. I want to say that please keep the manuscripts coming. This is just the maiden one. I assure you it will get bigger from now on. And lastly, of course, I want to thank my colleagues on the arbitration editorial board, Dr. Hakim Seriki. Even though he's based in England, we had so many endless discussions by WhatsApp, and anytime I was in the country, we got together and we were always talking about how do we progress this idea. Professor Ofonze Amochosi is a commissioner in Anambra State, so he's unable to be in attendance, but I'm sure he's online and he's joining us. Mrs. Sheung Olontimeyi is also not physically here, but I'm sure he's in attendance. And of course, Mr. Unduka Ikei and Mrs. Chinwe Ojigwe. Thank you so very much. I'm grateful to all of you that have joined, and I thank you very much.